Hello everyone. Very quick video on chattels and fixtures because we were having a lot of different phone calls concerning the topic. I thought it would be a good opportunity for me to quickly chime in with my legal sense and an opinion in the matter. So first and foremost, most people are using the OREA agreement of purchase and sale. The default presumption arguably is that if something is physically attached to the property, it will be included in the purchase price. So as an example, if I'm buying a house, I don't need to necessarily say that all the doors are included, all the windows are included. It's automatically assumed that if the property or the item is physically attached rather to the property itself, then by default those things are included as a part of the actual transaction. On the other hand, we have what we call chattels. Chattels are personal movable items. If you don't specifically mention the chattels that you are bargaining for as a part of the agreement of purchase and sale, unfortunately they will not be there on the closing date. And if you are under the impression that they will be and they're not in the agreement, because there's an entire agreement clause in the agreement of purchase and sale, more than likely the seller is going to say, unfortunately, you did not bargain for it, and that they are not in any sort of an obligation to leave it behind. We've seen very funny situations where, for example, the center island in the kitchen was removed by the sellers on closing, and the argument that they made was that it was an actual chattel, it was a personal movable item rather than a fixture that was physically attached to the property, and because it wasn't bargained for pursuant to the agreement of purchase and sale, they were within their rights to remove it. When you are drafting your contract, we are of the opinion that you always paper over everything. If there's any sort of uncertainty, you paper it over, whether it's something like a chandelier or a wall-mounted TV, or simple things like window coverings and the fridge, the stove, the washer, dryer, just to ensure that there's no inaccuracy or misunderstandings. If it's being specifically excluded and it's a fixture, something physically annexed to the property, just make mention of it in the actual agreement of purchase and sale under the fixtures excluded section. And on the flip side, if it's a chattel and you want it, a sofa, a fridge, a stove, something that's not built in or physically attached to the property, just mention it as a part of the agreement of purchase and sale under the chattels included, so that you will end up with it at the time of closing. The example that really resonates with me when it comes to differentiating between chattels and fixtures is one I read in a legal book, whereby the example was of a brick. When you purchase a brick, it starts out as a chattel, it's a personal movable item, but as soon as you take the mortar and you cement it to the actual wall, by virtue of the annexation, that chattel then becomes a fixture. So at the end of the day, the differentiation between the chattel and the fixture is based on the level of annexation to the property. So do keep that in mind. The last point I can quickly make in passing concerns the rental items. We've noted many contracts that come through our office that don't account for rental items, and sellers who know that the items are rented and not owned, who fail to account for those provisions in the agreement of purchase and sale, end up in a lot of trouble because the buyers say, well, we never bargained for a rental item. It was automatically understood and assumed that because there was no rental item mentioned in the agreement, that the hot water tank or the furnace or what have you are included in the purchase price. We've seen situations where, unfortunately, the sellers are forced to pay, $10,000 to $15,000 to discharge those security interests that are registered against title because the item itself is rental rather than something that was owned. So be very careful. Go through the various provisions of the contract very carefully and diligently. If you're using the support of a real estate sales representative or broker, then have them go through the contract with you so that you're aware of what you're bargaining for, what's being included, what's not being included, what is specifically being included, and make sure you account for any rental items. I hope this video helps. We'll see you again next time.